Hello, everyone, and welcome to Uncivil Law, where we gain legal knowledge through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe and hit the notification bell. It helps us grow. For today's case, we're dealing with someone who wants to sue the police officer for a violation of his Miranda rights and offering that testimony in court. This is the case of Terrence Decoe versus the County of Los Angeles and Dennis Stragland. In this case, there was a confession that was offered in testimony. The guy was found not guilty. And now he wants to sue over it because he says he wasn't offered Miranda. He says he was supposed to. This is in violation of his rights. So we're going to read this case, see what it has to say. Let's get started with this. Terrence Decoe was working at a Los Angeles medical center when a patient accused him of assault. A deputy found Decoe in an MRI section where he was working, transport patients to and from their MRIs and their rooms, and the two went to a nearby private room to talk. Though the deputy questioned Decoe, he did not advise him of his Miranda rights. This is uncontested. By the end of the questioning, Decoe had written the following statement: "To who, sick, it may concern." That's just being very anal because technically it's to whom, but who writes that way, right? "This is an honest and regrettable apology from me about what happened a few hours ago. It was, I don't know what suddenly came over me, but was certainly the most weakest moment I've ever caught up with in my life. I've never ever found myself doing such a despicable act, and I don't think this is an excuse, but I'm single, and I currently don't have a girlfriend, and became very excited after I first saw her female parts accidentally. So after dropping her off, I decided to go further by working and spreading her for a quick view, and then I went back to my duty post with the intention of self-pleasing, which I never did." So there's an accusation of sexual assault. He's helping this woman purportedly with an MRI and may have touched her inappropriately while doing so in order to touch himself or something. And then how Decoe came to write the statement is disputed and brings us to the rise of this 1983 claim. In Decoe's telling, when the deputy first approached him, the deputy asked if there's somewhere they could speak in private, which I believe. Decoe's co-worker suggested the MRI reading room, which is a small, windowless, soundproof room used by doctors to read MRIs. When Decoe's co-workers tried to accompany him, the deputy stopped them and told them the interview was private, which I also believe. The deputy shut the door and stood in front of it. So this is kind of where the disputed part comes in, right? The deputy shut the door in this reading room and stood in front of it, blocking the path. He then accused Decoe of touching the patient inappropriately. Decoe adamantly denied the allegation. After approximately 30 to 40 minutes, during which Decoe refused to confess, the deputy told him falsely that had been captured on video, so he might as well confess. So this is a common tactic, as you well know, that the police are well able to lie to you. So they say, well, we captured on video. Still, this person did not confess. Decoe then, according to him, asked to speak to a lawyer, but the deputy ignored the request. At that point, Decoe grew frustrated and tried to leave the room. Decoe testified, "I made one or two steps, and the deputy rushed at me and stepped on my toes, put his hand on his gun and stated, 'Mister, I am not repeating that language. There's no way in hell. Trying to be smart with me. You make any funny move, you're going to regret it. I'm about to put your African American behind where it belongs, about to hand you over to deportation services, and you and your entire family will be rounded up and sent back to insert racist place here. Trust me, I have the place to do it. Power to do it.'" So Decoe over here is telling a pretty interesting and somewhat difficult to believe tale, to be honest. According to him, this deputy said some of the most racist things possible and touched his gun and threatened him to block his exit. So not only was he custodially interrogated, he was threatened with a gun. Okay. The deputy then grabbed a pen and paper, put them in front of him, and told him to write what the patient said he did. When Decoe hesitated, the officer apparently, according to him again, put his hand on his gun and said he wasn't joking. According to Decoe, Vega then dictated the contents of the written confession, and Decoe, who was scared and ready to write whatever he wanted. So Decoe is telling one hell of a tale. Let's take note. Of course, it might be true, but under this telling, The officer takes him into a private room to be investigated or interrogated or interviewed, which I believe, right? Put him by himself because it's sensitive for no other reason. But then the officer blocks the door, calls him racist names, puts his hand on his gun, tells him to write a confession, and when he resists, puts his hand on his gun and says, "I'm not kidding." So this would be pretty blatant under Teko's telling of the story. So I'm a little skeptical that happened, but let's listen to what the deputy said happened. The deputy testified to a much different version, as you might expect. According to the deputy, when he first arrived at the MRI, he asked Teko what happened, and Teko said, "I made a mistake." Teko asked if he could talk to get away from his co-workers and get a little privacy. After the two went to the room, Vega handed Teko a sheet of paper and said, Can you write what happened while I get my sergeant and we ask you a couple questions?" According to the police officer, Teko then wrote out a confession himself without further prompting, which is slightly more believable, but still somewhat difficult to believe. But stranger things have happened, but yeah. Another officer arrived soon thereafter, joined the deputy in the room. According to this other officer, Teko indicated he was willing to talk to the officers. The deputy then questioned Teko in a very conversational tone, and Teko verbally admitted to touching the patient inappropriately. The sergeant testified that Teko's demeanor was that of a man who's contrite, who regretted what he did. So we have two very, very different tales of the story. We got the officers arriving at the hospital to interview Teko. They take him to a room. In one version of the story, they essentially threaten him after calling him racist names, putting the hand on the gun, and say, "Confess or else." In the other version, he just openly confessed without prompting. I'm not sure I necessarily believe either one of them, but yeah, that's the two narratives we have going on here. So let's figure out what we should do about this legally. Teko was arrested and charged in California state court with unlawful acts under California law. Early on in Teko's first criminal trial, before his confession was introduced, a witness for the prosecution revealed evidence that had not been disclosed to the defense, and I have no idea what that is, but with Teko's assent, a mistrial was declared. So there's some kind of evidence and mistrial. During Teko's retrial, the prosecution introduced the confession as evidence of guilt. So presumably, the trial court in the criminal case, there was, I don't know for sure because they're not saying, but presumably there was some evaluation as to whether or not this confession could be offered without Miranda, and it was, but the jury returned a verdict of not guilty for whatever. So he was found not guilty. So after acquittal, Teko filed for action under 1983 seeking damages for violation of his constitutional rights. The case began with several claims against multiple people, but only one issue now. The claim is Vega violated his rights against self-incrimination. Before the first trial in the case, Teko asked the district court to instruct the jury. It should find in his favor on the Fifth Amendment claim if it determined the deputy obtained statements in violation. This would be his civil case now, right? So in his civil case, Teko asked the district court to instruct the jury. It should find in his favor if it determined the deputy obtained statements in violation of Miranda that were used in the criminal case. And because the only issue in dispute on this theory is whether he was in custody, which would be the principal issue, is he legally in custody? During that questioning, Teko submitted a proposed jury instruction to inform jury factors. The district court refused to instruct the jury on Teko's theory, reasoning the Supreme Court's plurality decision in Chavez held that Miranda was a prophylactic rule rather than a constitutional requirement, and 1983 plaintiff like Teko could not use the prophylactic rule to create a constitutional right. All right, so there's a whole lot of things going on there. So the Miranda decision itself, when they said that you have to inform a suspect, you have the right to remain silent and all the rest of it, the district court said to themselves, okay, this isn't exactly speaking a constitutional requirement. It's instead a prophylactic rule. And God knows there's enough language from enough decisions for the district court to reach that conclusion. So if you're thinking to yourself, that doesn't make any sense, let me assure you, it makes sense. that has been described as a prophylactic rule on more than a few occasions. So the district court says, okay, this is just a merely prophylactic rule. It certainly exists, and it exists to the point that it would allow evidence to be excluded at trial. Now, apparently that didn't happen because it was offered at trial. So apparently Miranda wasn't necessary. But assuming it was necessary, it would only be necessary for the purpose of whether or not the evidence can be offered. So the failure of the government to offer it doesn't provide a civil remedy. It only provides a remedy in terms of the exclusion of evidence at trial. That's the dispute. Does it extend further than exclusion of evidence? So the trial court said no. It only extends to the exclusion of evidence, which strictly speaking isn't constitutionally required, but we're doing it because we think it's really good. And again, there's more than enough language to come to that conclusion. So the district court says, well, since it's not constitutionally required, you can't sue under 1983 because it's not a violation of your constitutional rights, which makes sense. So they refused to give the instruction, and as a result, the jury returned a verdict in favor of the deputy. After trial, however, the district court concluded it had erred in instructing the jury to evaluate it as though it were brought under the 14th Amendment instead of the 5th Amendment. So the trial court initially said this is a 14th Amendment issue instead of a 5th Amendment issue. Okay. So it therefore ordered a new claim because it felt like it gave the wrong instructions. So the jury, again, the instructions were again contested. Ultimately, the district court gave the following instruction on coerced convictions. So here's what they gave in the second trial. For the civil case, you must consider objectively, totality, all the circumstances. Whether a confession is improperly coerced or compelled depends on the details. Factors to consider include, but are not limited to, the location in which questioning took place, for example, at a police station or a public street, and where the location was chosen by the person or the officer. Was a person free to go, or was the person arrested or physically restrained? Was the length of questioning oppressive? Was the plaintiff told at the beginning, at the encounter, and throughout its duration? The manner in which the person was questioned, for example, was any force or infliction of pain used? Was the person threatened, either psychologically or physically? Was the officer's gun drawn? Did the officer continue to shout at the suspect? If warnings under a Miranda decision were required, whether the police advised them of that right, and any other factors. So the district court said, this isn't really Miranda as such. Miranda is a factor, but not the only factor, because the constitutional violation, according to the district court, would be if the confession was coerced. Miranda being a factor, but not dispositive. All right. And again, with all due respect to the district court, this is probably a reasonable read. So before we give the district court too hard a time, I think they're probably at least reasonable. So then again, we gave a verdict in favor of the deputy and TCOA appeals. So there's a question as to what the jury should be charged with. What is the law? That's a very good question. What is the law here, right? So is Miranda constitutionally required? Is it merely prophylactic? What's the standard? How do we determine if a violation occurred? All that good stuff in order to determine if a lawsuit should go forward. So TCOA is appealing and saying you gave the wrong law. All right, so we have to figure out what the right law is, so let's do that. Under 1983, a plaintiff may bring suit for damages against a state official who deprives him of any rights secured by the Constitution. Whether a district court should have given the proposed Miranda instruction turns on whether the unmemorized statement was a violation. So if it wasn't a violation of the Constitution, then it can't be a violation of 1983, which makes sense. So we have to figure out, should he be given Miranda? Okay. The Fifth Amendment provides no person shall be compelled to be a witness against himself. In Miranda, the Supreme Court implemented this guarantee by setting forth some guidelines for officers to follow when conducting custodial interrogations. Custodial, of course, being a key word there, because whether or not this was custodial within the meaning of the law is unclear. Under Miranda, before an individual is interrogated, custody again being key, he must be advised he has the right to remain silent. Any statement he does make may be used against him. He has the right to an attorney. In the decades that followed, there was significant debate about the extent to which these warnings were constitutionally required. On the one hand, the opinion itself appeared to contemplate that statements taken from defendant who had not been given Miranda were compelled and thus obtained in violation of the Fifth Amendment. On the other hand, the Miranda decision itself left open the possibility that the specific warning set out might not be necessary if states or Congress devise other means of protecting the compulsion of the process. So the Miranda decision itself seemed to suggest that Miranda warnings themselves are not required if some other stuff happens. And then the court itself, the U.S. Supreme Court, muddling the issue, which is why the district court didn't really screw it up, the Supreme Court itself described the warnings as prophylactic rules, procedural safeguards that not themselves required. See, for example, several citations from the U.S. Supreme Court. So is this constitutionally required or is it prophylactic? And the answer to both those questions is yes, because it's confusing. So that's where the district court, So the issue comes to a head in Dickerson. Dickerson concerns a federal statute, one might take note, enacted in wake of the Miranda that provided that confessions were admissible as long as they were voluntarily made, regardless of whether Miranda was provided. So the federal government's coming in and saying, okay, we're trying to overrule Miranda. All right, whether that rule is possible turns on whether the Supreme Court's talking about the Constitution or not, right? If it's the Constitution, then Congress can't. And if it's not, then Congress can, right? So can Congress overrule this by statute? Good question, particularly when you're talking about them being prophylactic. So the court acknowledged all this language in all these many, many decisions that might lead the Congress to reasonably conclude that they can do this, but then ultimately concluded that Miranda was in fact constitutional, that Congress couldn't overrule. Okay, so Dickerson strongly supports Toccoa's argument that you can bring a 1983 claim predicated on Miranda when un-Mirandized statements are used against them in criminal proceedings when Miranda is required. 1983 permits suits for damages to violate rights. And because Dickerson makes that clear, we conclude that that was the rule. Okay. But wait, there's more. Because of course there's more. Because of course there's more. We can't have things be nice and simple, right? Miranda said two different things at the same time. There were a whole bunch of decisions that described it as a prophylactic rule. There was a case called Dickerson that said this is not a prophylactic rule, it's constitutionally required. Great. Issue resolved, right? Not so much, because then there's this case called Patain. In Patain, the court held in a fractured decision the Constitution does not require the suppression of physical evidence that's held in violation of Miranda. Okay, so then, at least as far as federal law is concerned, how far does Miranda go? Right? Fruit of the poisonous tree. Kind of idea. So the federal Supreme Court said in a very, very fractured decision, very fractured, that it extends to the statements but not to the physical proceeds. So fruit of the poisonous tree may be a thing in some states, but not really under the federal law. So as to say Supreme Court. Or maybe not, because it's fractured. Right? So, yeah. They further conclude that a constitutional violation on failure to give Miranda could not occur until unwanted statements were admitted to trial, at which point the exclusion would be found to be a complete and sufficient remedy for the violation. Uh-oh. Right? Uh-oh. And that's Justice Thomas writing for a four-person plurality. So now we're in the situation where we have to count votes. This is now the situation where we have to count to 5. And let's have fun counting to 5. Because this is the bad part when the Supreme Court writes fractured decisions. How do we count to 5? This is not trivial. This is a pain in the ass. All right? So Justice Thomas, writing for 4 people, said, there's no constitutional violation for failure to give Miranda until the statements are offered at trial. And then the only remedy is the exclusion of the statements themselves. Not even the stuff that flows from them, just the statements. So it is constitutional, it's constitutionally required, but that being the case, there's no violation that occurs. So even though it's constitutionally required, it's not a violation of the Constitution not to offer them until they're offered, at which case exclusion is complete and sufficient. That's the only remedy you get, says Thomas, writing for 4. So now we have to figure out, can we get to 5? Fun times. Previously, in a different case called Chavez, the Supreme Court had confronted the question of whether a plaintiff could sue under 1983 for an officer's failure to give Miranda when the plaintiff was not charged with a crime, and therefore the statements were never used, right? In a fractured decision consisting of 6 separate opinions, so no way to count votes on votes, none of which garnered a majority of anything, the court held such claims are not vulnerable. So if you're never charged with a crime, right, then you can't sue because they're never offered against you in a fractured decision. The only thing on which we agree is the result. No rationale. So if you're not charged with a crime, you can't sue if they don't give you Miranda. Okay, but what about if you are charged with a crime? Yeah. The specific holding in Chavez, therefore, does not govern this situation because there was a criminal trial. The district court ran Chavez to stand for a broader proposition that 1983 can never be grounded on Miranda, that's perfectly reasonable read, right? It's a fractured decision, fractured to hell. It says you can't sue if there's not a criminal case. So, but if there is a criminal case, what? And the district court says no. In adopting this reading, the district court treated Justice Thomas's plurality opinion as supplying a controlling precedent. So the district court, trying to count to 5, says, I count 5, which, given how hard it is to count in Supreme Court opinions, is perfectly reasonable. United States versus Davis, our court sitting en banc, examined the question of what we should do when there's a Supreme Court fractured decision, and applying a very famous case called Marks. All right? So there's a Supreme Court case that says, how do you count fractured votes? So in Marks, we've said that a Supreme Court decision only binds federal courts when a majority of justices agree upon a single underlying rationale, and only one opinion can be reasonably described as a logical subset of the other. When there's no opinion, only the result is binding. So there's only a binding opinion if the majority agree upon a single rationale and an opinion that we're trying to count as a fifth vote can be understood as a subset of the other. Okay? So we say Marx instructs us to consider the opinions only of members who concur on the narrowest possible grounds. So we're trying to find the least common denominator when we're counting in 5. Okay, fair enough. That's a perfectly fair thing because this whole thing is a world of confusion. So the district court is looking at this reasonably, so is the Court of Appeals. It's a mess. So now the Court of Appeals has to apply all this. And so they say, when applying Davis to Chavez, we conclude that none of the opinions provides a binding rationale. There is no binding rationale from the U.S. Supreme Court, which may or may not be true because Marx is a mess, everything is a mess. Justice Thomas's plurality opinion, which reasons in dicta that damages are unavailable from Miranda, does not command a support of 5, and was based on a rationale significantly broader than the concurring. No matter what, that's got to be a reasonable opinion. Because, yeah. Thus, contrary to the district court, the broad principles are not binding here. So, sure, because, yeah, and did the district court screw this up? I mean, probably not, to be quite honest, even though the Court of Appeals is coming out differently, because this is hard. But they say, Justice Thomas, when they said you can't sue, it's not binding. Let's go with that for the moment, sure. When, as in Chavez, no common denominator of a court's reasoning exists, we're bound only by the specific result. Okay. The specific result from Chavez does not and cannot apply to this because there was a criminal trial. We know what happens if there's no criminal trial, but the Supreme Court has not told us what happens in a criminal trial. Okay. Under our holding, therefore, this opinion cannot control. Sure. Thus, we're left with Dickerson for guidance, which, as previously discussed, led us to conclude the use of unmeritorious statements may violate the Fifth Amendment, which, to be quite fair to everyone involved, is just as reasonable a conclusion as anything else. So sure, why not? There's a cause of action for an un-Mirandized statement that's offered if there's a criminal proceeding that extends beyond the exclusion of the statements. Sure. Okay, let's go with that. Okay, so having concluded that, unfortunately, the U.S. Supreme Court's guidance is less than exemplary on this issue, which, yeah, and having concluded that there might be a freestanding cause of action, if there was a criminal case, to sue the officer for introducing the un-Mirandized statement, assuming it had to be Mirandized, incidentally, which the very fact it was offered at criminal trial suggests not. But yeah, you might be able to sue. Okay, so now we've determined that you might be able to sue. Let's figure out whether or not you can sue in this particular case. Let's do that. To hold the deputy liable under 1983 for violating the rights, Tekoh must prove that his un-Mirandized statements were used against him and that the violation caused the rights against self-incrimination. While the question of liability is ultimately for the jury, we conclude Tekoh sufficiently demonstrated a Fifth Amendment violation caused by a deputy, such that the district court erred by failing to instruct the jury. Here, there's no statement that Tekoh's statement was used against him. There's also no question the deputy caused the introduction of the statement, even though he was not the prosecutor. We've explained that government officials, like other defendants, are responsible for the natural or foreseeable consequences of their action. Similarly here, although it was the prosecutors who used Tekoh's statements at the trial, it was Vega who interrogated Tekoh, prepared the report, and personally signed the declaration. In those documents, he stated he was a suspect. He arrested him for a charge under law, and the incriminating statements were the basis for probable cause. As a result, a jury could infer the introduction of the statements was reasonable foreseeable conduct. So if he violated his rights, then he doesn't get an excuse because the prosecutor intervened, because it was foreseeable result. So there's no interrupting of this that would avoid liability, assuming he was liable in the first place. We do not hold that taking an un-Mirandized statement always gives rise to 1983. We only hold that when government officials introduce an un-Mirandized statement to prove a criminal charge, a 1983 claim may lie against the defendant or against the officer who took a statement. Okay. Therefore, the district court erred by giving the coerced confession instruction rather than by instructing on Miranda alone. So rather than this multi-factor, was it coerced, where Miranda's only part of the equation, because Miranda wasn't constitutionally required, remember, according to the district court. But apparently, since it is, sort of, kind of, maybe, then we should have instructed on that alone. So if Miranda was violated or not. Okay. First, to establish the violation, Tekoh needs only to demonstrate he was in custody when he was questioned. Correct. Miranda is required if there's custodial interrogation. We've got interrogation for days. The question is it custodial? The district court instead required Tekoh to prove that confession was improperly coerced, which is not required. Vega acted intentionally in obtaining to act that coercion, not required. We cannot presume the jury would have found Tekoh was not in custody if it had been properly instructed on the claim. Given what I know right now, I'd be hard-pressed to say that this is custody, but sure, let's give a jury a go. Vegas concedes whether or not he's in custody involves a disputed question of fact that turns on a credibility determination. That's true, I suppose. So that does make it a jury question, correct? So they should be instructed on the correct law to determine, is he in custody? Who do you believe? All right. We do not and cannot know what a jury would have found as to this question. The district court instructed the jury to assess whether they were coerced under a totality of circumstances, unlike the Miranda violation. It's entirely possible to find that they're in custody, because that was only one factor. Apologize, that they weren't in custody, or yeah, was in custody for the Miranda violation, but overall not so much. Because Miranda was only one factor of 7. So if they had found that but not found the other factors, then they would have reached the wrong conclusion, apparently. So we don't know what they thought about custody or not. Okay. Therefore, we cannot conclude it's more probable that the jury would have reached the same verdict with the proper instruction. Because we do not believe the deputy has made the showing, the error was not harmless. We thus vacate and remand for a new trial in which the jury must be instructed that Miranda is what guides, and so what matters is whether this is custodial or not in order to establish the violation. Thus, that brings us to the end of the case of Terrence Tekoh versus City of Los Angeles. In this case, Tekoh gave a statement regarding a crime for which he was found not guilty, and the statement was not given with Miranda protections, and he'd like to sue. And in a very complicated analysis that I'm not 100% sure is correct, but I'm also not sure is wrong because the case law is a mess, so your guess is as good as mine, but the Ninth Circuit says, sure, you can sue. Of course, in order to win, you have to show that's a constitutional violation. Miranda being required, therefore you have to show that this was in custody. So can you show it was in custody? So there's a trier of fact to figure out. So the jury must be instructed that what matters is whether or not it's in custody. They'll have some testimony, determine liability. I have no doubt in my mind there will be an appeal, so this is definitely not the end of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye. This might be a decision that's making my head spin more than any decision of recent memory, because we're doing with fractured votes and splits of splits and splits, and oh my God. And all I can really do is throw up my hands and be like, yeah, that's fine.